I'll come back now to the meaning of the term neutralize in the context of this case. It's open to interpretation in the abstract, but my friend, in trying to persuade your honors to take the view that neutralize didn't mean anything nefarious, quoted statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was at T006, page 31, lines 2 to 11. So he's been criticizing the credibility of our witnesses, cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog. And Mr. Kaufman said, yes, but Mr. Espinosa surrendered. And then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10. In the PRRD list, it was brought up, I believe, in the presentation. These two victims of incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these, when he can, as some kind of mantra that supposedly exculpates his client. Does not. As I said, this is the lawyer, Duterte, trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them, but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honor should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30, lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7. He said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify. And for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath?